Metropolitan Government of Nashville, Davidson County Community Review Board. This is August monthly meeting. We're here at Sevier Park, Community Park. We call this meeting to order. Reading of the appeal statement by Attorney Clark.
Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, please take notice that the decisions of the Metropolitan Government of Nashville and Davidson County Community Review Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of certiorari. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met.
Okay, do we have a quorum?
We have.
Okay. The next item on the agenda, approve the minutes. Get a motion to accept the minutes.
I move, was that correction made? I move minutes be approved.
Do we have a second? Okay, that been a second by Board Member Wynn. All in favor say aye.
Aye.
Anybody disapprove? Okay, thank you for that. Next item is the chair remarks, which don't have a whole lot to say. Number one, that we are getting some response from the mayor's office, but I don't agree with everything that's been sent out to us. I'm hoping that when we have a particular folder pertaining to certain incidents, when we send out a letter and we get a response, everything maintained in that particular folder, because if we had to go to any legal proceeding, we can show where we have sent out letters to the mayor's office, or we sent something to the DA's office, or we got a response from them, so we know exactly the dates and the time that we responded, and then we had a date and time that they responded back to us. It's more or less a track record, and we want to make sure that we're very efficient what we do, and we don't want anybody from the police department or the mayor's office say that we're not doing our job. We want to be on top of everything. And I appreciate everybody that's here in attendance today. Okay, let's go with, do we have any public comment?
No, not at this time.
Okay, if we get something towards the end, we will reflect back to that. Okay, and let's move on to the Executive Director report.
Okay, thank you. I did want to acknowledge that Lieutenant Cantrell is here from MMPD. Thank you. All right. So here, I'm just going to go over a couple things that I think are important. For September and October, we were thinking about doing our meetings in the community. We know that September may be a viable month. October won't, just because it's NACO and a bunch of us will be gone. And so we want to make certain that, so I'll let you know. That'll be to be determined if we can even find a location at this last minute for October. But if not, we'll be back over at the Sunny West room, because the remodel is complete. So just to let you guys know that.
While you're looking at that, also look at the second part of October, not the first 2 weeks of October. That's been already spoken for.
Oh, that's right. Okay. No problem. I wanted to talk a little bit about our complaints. There has been an uptick in our complaints. We have, this month, there was 10 civilian complaints since our last board meeting in July. 1 accommodation and multiple calls for service. And so that takes me into, here's the page, sorry. Also, all of our cases have been presented, that were presented at the board, that needed to go to the chief for review. They have been sent, they have been sent. And so we're waiting to hear from the chief in regards to outcomes on those cases. And we haven't heard anything yet. We'll have to I'll send out a notification of the cases that have reached the 45-day mark, just as a reminder to him that we need a response to those, as per the agreement with the MOU. As it pertains to records, I wanted to talk a little bit about this because I think that this is, we're still in the same place, it seems. Like we make progress and then progress stalls and we're back to square one on certain things. So for the most part, when a case is completed with OPA, it goes into this shared link. I'm sorry, it's not a shared vote. It's a link that they send us. In that link is their investigation file. Sometimes it has portions of the body-worn camera, sometimes it doesn't, okay? Which means that then we have to make an additional request for body-worn camera footage, all right? So what I wrote here was the NCRB investigators reported that they continue to have delays and pushback receiving body-worn camera video footage and some records per the MOU agreement. The delay is happening related to complaint cases where OPA have completed their administrative investigation and closed their case. However, the case may be assigned to detectives outside of the OPA agency, and the information related to the complaint case is being denied, with detectives citing Rule 16 as one of the reasons for denial. I wanted to just reiterate that complaints related to officer misconduct are administrative in nature, and the review of OPA's investigation should not be curtailed or delayed because of a pending criminal case. So for instance, if an officer has, there's some alleged misconduct with a case, and that case is a criminal case, for instance, that person, let's just say the person who made the complaint says that an officer used excessive use of force on that person. And so that case then, sometimes it's involving the complainant, sometimes it's not. Sometimes it's a witness. And so that case would then go on to criminal court for whatever charges, but the administrative portion of that case would still be investigated by OPA. OPA then would finish that case and say, this officer was either, is being held liable, exonerated, the allegations were sustained, and they go and they finish their case. But then we can't get that information, although this particular case is an administrative case and not connected to the criminal. I mean, it could be connected, but it's the administrative portion of this excessive use of force is being investigated by OPA at the same time that a criminal case is happening. So I don't understand why we wouldn't be able to receive the same information that they have made their decision on. Because what we're doing is reviewing their case, not the criminal court case. And so it is a Rule 16 issue. I don't even think it really is a Rule 16 issue, but they want to say it's a Rule 16 issue. So I think that that's where we go back to, I mean, we've been to the drawing board multiple times related to this. So the law says if the case is closed, so that the administrative portion is closed, not the criminal case. Could be still pending. Frank?
Question, on these cases and on these where the officer is involved in a complaint and it could be criminal, the body camera probably should be on some of the incidents. But what happens? What are their recommendations if the body camera is turned off and you're not recording the complaint that the people see it happen? You know.
Yeah, I mean, if they've made their determination and closed their case, that means that they have reviewed all the evidence that they had, which would include body-worn camera footage. It could be external footage. It could be witness statements. It could be a host of things. But if OPA has closed their administrative case, what we're doing here is reviewing administrative cases. we're not reviewing a criminal case. We are reviewing whatever documentation and evidence that they have to make a determination on whether an officer has violated MMPD policy. That's it. You understand what I'm saying? Okay.
Attorney Clark.
I would recommend that each time anyone on our team runs into this Rule 16 reasoning, not to say excuse, reasoning, that you let me know about it, and we talk directly to Cindy Gross and Green and Widener, who said it was a non-issue. And then we can also loop Glenn Funk in, because if we need to see something and a prosecution's being held up, this was addressed in our memorandum of understanding. The way that you and me and Mr. Goddard remembered that conversation was different than the way that Green and Widener and Cindy Gross remembered it. In any event, we agreed last time we met for us to communicate when an issue comes up. So I'd like to personally know about it when that is used as a reason for us not to get body cam footage on a case that is closed with a complete administrative review, because that is outside of anything we've ever agreed to. And we need to have some procedure to find the footage, regardless of whether or not a case is pending. That can't be a blanket reason to deny footage. So that'd be my suggestion.
Right.
I'm all ears if anyone else has any more.
Mr. Holloway. Mr. Holloway.
Yes, so, I mean, this is the very thing that we talked about in our meeting with Cindy Gross and Tommy Widener and Dwayne Green. And so I think you're exactly right, Attorney Brazil. When we come across any of them, I don't care if it's 4 or 5 of them a week, we are addressing them at that time.
Yeah.
So, because we cannot continue to rehash and every time we have is it the same investigator, a new investigator? I'd like to really kind of know where this is coming from so we can address the problem, because if it's not a problem with the deputy chiefs and the attorney for MNPD, and we keep running into this problem, then it's maybe something that they will need to address on their end, but we need to go ahead and nip it in the bud because it's prolonging, our work. And so if we can just, make sure that, number one, we have all the case information, but at the same time, we need to make sure that wherever this misinformation or miscommunication is happening on the side of MNPD, that we get that taken care of.
Question, you said we who met with Green? What group?
I can address that.
I'll answer it. It was myself, Executive Director, I was going to say Executive Director Hattie, Executive Director Fitcher, I'm Hattie, Attorney Brazil, Drew Goddard, Cindy Gross, Tommy Widener, and Dwayne Green, when we were in a meeting about 2 months ago, when the board voted that I would be the representative from the CRB to attend a meeting with the attorneys with MNPD.
That's good. We just want the record reflect what were we talking about. That's all I'm making. Is somebody raise their hand? Woman Wing.
So can we back up a little bit, Director Fitcher? You said that you wanted to deal with a problem where an officer was under investigation administratively through OPA, and there was a criminal investigation parallel to that, right? You have 2 investigations.
Correct. So if an officer, and this is hypothetical, I don't know we have multiple cases.
Okay.
But for instance, if a case where, I have a case that just came in where a woman, let's just use that case. Well, let's not use that case. So for instance, if a person has just made an allegation that the officer used an excessive use of force.
Okay.
All right. And that person does have or sustained an injury. And so the administrative case, which is the OPA investigation, they went through the process, and when they went through that process, they either, I don't know whatever the outcome is, the outcome it is. Then they closed it because the OPA investigation, the administrative portion of that case is closed. All right. And so what that means is that is the time when, you know, should be able to review and look at their investigation and present it like we have, because we're not considering this other issue, which is the criminal case. We don't have any stake in that. What we're talking about is an officer who has been accused and has went through whatever administrative processes that have been set in place, and so that we can conduct our work and finish that work.
Okay, so my question is, wouldn't it be prejudicial to the accused officer in the criminal case for us to publicly discuss information about the misconduct that's connected to the criminal offense that they're charging? In other words, would our review of it influence the court's or a jury's view of an officer in a criminal case? Wouldn't that?
It could, but every case may not be related to that.
But
right?
if it's the same complaint, in other words, if the department's got a complaint for excessive force and it turns into a criminal case, they're running parallel. The administrative tracks running the criminal tracks when the detectives are different, but they're using the same information against the accused officer. OPA completes their case. Let's say they want to suspend him or fire him. Then wouldn't our review be prejudicial to that officer? In other words, would it hurt his case in the criminal case for another group of people to publicly review the OPA case?
Maybe in that particular instance, but there could be an allegation that has nothing to do with the case, right? So for instance, let's just take excessive force out, and now it's some other issue, right? It has nothing to do with a use of force. Maybe it is...
Or even the police officer.
Right, it could be something else.
But the prosecutor in the case would use everything in the officer's file in the criminal investigation. In other words, if I'm going to show that an officer's got a propensity to do certain things, and this is one of them in the criminal complaint.
I'm not talking about the officer being charged criminally. No. I'm not talking about that. I'm talking about the complainant.
Yeah, that.
Or even if that complainant, it may not even be a complainant. It could be someone who witnessed it, who filed the complaint. We're not talking about cases that involve an officer also being charged criminally.
Oh, I'm sorry. I misunderstood
Yeah,
you
that's
there.
not what I'm talking
I
about.
thought you had a single officer with
No,
an
no, no,
administrative sanction or investigation
Right.
and a criminal complaint.
That could be a Rule 16 issue. But I'm talking about everything else besides that.
Okay. Thank you.
Okay,
You're
Board Member Brown.
I think we may have some semantics. I think we're suggesting that Lincoln Hauser himself I think this may be somewhat of a matter of semantics. It would appear that if OPA says they've administratively closed the case, we should basically have access to it. And if it involves the criminal case, then you've got Rule 16 issues. So I'm puzzled why OPA would administratively close a case if it was their investigation actively actually impacted on the criminal case. And I think that's something our legal advisor could discuss with them. Because if I understand it correctly, if their investigation impacts the criminal case, they really shouldn't be closing and issuing a report, because if they find the officer was not negligent, the DA wants to, the defense wants to use that. If they find him negligent, the prosecution wants to. I don't think the court would admit it for either side, but it just seems like if they close it, we ought to be able to look at it. Seems to me like they shouldn't close it if it impacts the
Right.
criminal case, and we could sort that out with them, but because we want to proceed if we can.
Right.
Okay, Board Member Alicia.
Yes, I think that's a very good point, Board Member Brown. That's legally sound, but also we've discussed this issue. I'm really kind of coming from we've already talked about this. We've already settled how we would handle these issues going forward. So we need to move in good faith in that vein. So we said that we would let them know when this happened again, and so we should do that. But then also, they had no problem with us seeing that case, even if it was a Rule 16 and we had to go through the district attorney's office. So I would say, Attorney Brazil, you already have really marching orders in terms of how we handle that. But I think to Member Wynn's point, we weren't talking about a criminal case against an officer. It was more or less, really, I think the whole argument was a juvenile was mentioned in a case, and then it was deemed Rule 16, and it really had no bearing on the actual CRB case. And so now we have kind of come into, yes, a juvenile or a young person would be a Rule 16, but they weren't impacted within.
No, on that particular case, they were looking for a juvenile at a location. The juvenile was not there, and then there was this is a totally different, but there was some type of misconduct with an allegation of a force on a person that was at that particular address. And they wouldn't release that information to us, although a juvenile, even though the contact originated because of this search for a juvenile who was not present, but the misconduct or the excessive force was used against the person that answered the door. And so in that particular case, we were also denied based on this is a juvenile, this case has a juvenile, which they could easily redact the juvenile's name. We don't need to know anything about the juvenile. We are dealing with how this officer is alleged to have made some physical contact with this person excessively. So these are the kind of, I think this is what erodes trust in these processes when we shouldn't have to battle this. It's just common sense. We're not talking about a juvenile. I don't even want to know the juvenile's name. Has nothing to do with this. We are talking about an allegation of misconduct of an adult that has nothing to do with a kid. So.
Okay, Attorney Clark.
Yes, Attorney Brazil. It's important to understand and for us to remember that Rule 16, the one that we're discussing, is a rule of criminal procedure.
Right.
The police department has repeatedly taken the position in our meeting and in meetings before our meeting across the board that Rule 16 is not our issue, right? These are the prosecutor's files. It was for a long time that we had an agreement in place where we could freely access those materials and, of course, treat them as confidential, designated by law confidential. There's never a complaint we did anything but that. But for whatever reason, we're on different footing now. The department is reluctant to carry on business as usual the way it was under the old law. And they have reasons for that I won't discuss here. But the big point of this is we can't do anything about it if we don't have any knowledge of when it's happening, if I don't have knowledge when it's happening. Because if their position has been, this is all Glenn Funk's jurisdiction, let's take it straight to it and say, we need this. And we have reason to believe, he's stated it, he signed the memorandum of understanding that the police department refused to sign, that states, of course you can have it. You're the CRB. You're a government entity charged with oversight of police officers. It makes sense you'd want to see these materials. Also, the scenario that I understand, and it's important to make sure we understand that normally when Rule 16 is being raised, it's because there's some kind of a cross-referencing in the system that shows there is a criminal pendency associated with this complainant, or it can even be known associates of the complainant or someone who was at the scene. There's a lot of different ways something can trigger a Rule 16 hold. very few of which would be the type of scenario that Mr. Wynn's talking about that's obviously serious. We're not trying to pry into anything that could prejudice an officer's administrative process. Far from it. We need to be able to do our work, our statutorily mandated work. And I believe this is another, I will say excuse. I think the police department uses Rule 16 as an excuse. And because the messaging on at the table is, we have nothing to do with Rule 16. So it's interesting it's being raised by OPA as a reason to not produce files that are in some cases more than a year old. So I don't know, it's something we need to look at. I'd like the names of every case we have that deals with it, because we'll take it straight to Glen Funk.
Okay, Board Member Sean.
I mean, we may not know the answer to this, but do they, when something is like Rule 16 is flagged, do they not have a process for looking at the details of that to see like some type of review to see what those details are before they just, what's that? Yeah, they just deny it without looking at the details. Is that what it is? I mean, if we know that.
Mr. Witzel.
Yeah.
Yeah.
I think what happens is we send over the complaint. We send a complaint over. We think we have 4 active cases now. And I need to just review to see if they all are have the same information and the denial is, because once I read it, I can make a determination on whether or not this is a legitimate Rule 16 issue or whether it's not. What I'm referencing now is at least 2 cases that I know that may not be legitimate Rule 16 Brady cases, right? So this is not related to Brady, and they are lumping them all together. And so this is not about discovery in a criminal case. We're talking about allegations of breaking or violating MMPD policy, and they're including Brady in that. That's what I'm saying.
Right, and I believe that's the importance of us looking at it case by case, because we want to do our work in a way, I know, that isn't prejudicing anyone, especially an officer going through an administrative process. But that's not the bulk of these. This is being used as a reason to not produce materials, and we have a district attorney who will readily share them, but we can't access that procedure without some mechanism internally to let counsel know about it when this comes up.
Okay, Alicia made a comment to me, and I want her to repeat that comment to the board, and which is a good idea.
Okay, so all the cases that Director Fisher, that you all have come across, and this has been the issue, we send all that case information to Attorney Brazil. Attorney Brazil then takes it and he can discuss it with the district attorney, and in good faith let MNPD's attorney and know where we are with this. It's still happening, and then we move forward with a plan to hopefully not have to address this again, but at the same time clear up whatever kind of miscommunication is happening at MNPD.
Well said. Now, are there any more comments pertaining to our report? Okay.
Oh, for my executive director report? Oh, hold on. Yeah, sure. Thank you. I know we got off track into that a little bit, but I will get those cases and just a few other cases that I just want to bring to your knowledge, and then we can talk about it at another time. So right now we have some of this stuff is going to be talked about. It's kind of duplicated. The letter and the response that we got from the mayor regarding the 61-page complaint, he's going to talk about that, as well as the merit increase and update. You should have a copy of the goals and objectives. Keturah, did you pass that out already? Okay, so those goals and objectives are the goals and objectives that I met with the mayor and discussed. We did not attach KPIs at the time that we met. I added those for our own, just that we can keep up with what's going on with what we're doing. I did want to go back to community engagement, our campaign, Your Voice, Our Mission, because I think just in this short month, I want to say that I believe that information has assisted with people being empowered to, if they have encounters, to report that. Thus, we have 10 cases this month, and that it makes it more visible. And I wanted to take you to some of the community reports in regard to that in metrics. Okay, so the billboard report is that we have 5 billboards. One is on James Robertson Parkway. One is on Dickerson Pike and Trinity Lane, Charlotte and 28th, where the 28th and 31st Avenue connector is. One on Jefferson Street and one on Thompson Lane at Franklin Pike. And we've had so far 2 million in 30 days, 2 million, almost 500 impressions. All right, so that's been helpful. And then the next thing is I want you guys to save the date. We have a event in Bordeaux. It's our annual fall festival. It's Saturday, November the 8th. It has, last year it was just a phenomenal time. Some of you came out and supported, and it was enjoyable. And it's for the kids right after, they say it always rains on Halloween, so this is their opportunity to have some outdoor activity the weekend after that. So we pushed it back because of NACO, kind of coincides with that. It will be at...
Is it Hartman Park?
Yeah, Hartman Park.
And this is called a Fall Fest.
Fall Festival. Mm-hmm. And as it pertains to NACO, I'm on 2 panels this year. Ms. Cash has been invited to be on a panel with the New York City CCRB. Good to know that, thank you. And so that is underway. And so that kind of concludes the most important things. Of course, research and development is happening. We are working on 3 reports right now. The immigration report, which is an informational report, just to kind of read over executive orders, make certain that the community is aware of what is happening with that. We will share that. It kind of breaks down what those, what the meanings of those executive orders are, and it takes it from, local, state, and federal. So when that is released, we'll share it with you. If you looked in those goals and objectives, you see that we said that we will be putting out informational reports. We have an annual report that'll be coming up soon, and then, we'll go through the same process that we've always had when we have policy advisory reports. So the use of force report is an annual report, as well as the traffic stop and arrest report. Those are our annual reports that will we will create those every year. So you should, be on the lookout for those as well. That concludes my report.
Okay, Board Member Alicia.
What time is the Fall Fest?
What time is the Fall Festival? 11 to 3. Okay. And we'll start gearing up to that. So looking forward to that.
All right, could I get a motion to accept the report as presented?
I motion to accept the report.
There's a second?
Second.
All opposed? All in favor? All opposed? Okay, that's all right. That was just a test, that's all. Okay, thank you for the report. Now, next thing, item on the agenda, we're talking about board discussion. We will be dealing with A, rules and bylaws. Board Member Brown.
Okay, Mr. Chair, we've been over this a number of times, and I believe we have a clean draft that's been presented to the board members. I'll confess that I've made one error, and if you'll refer to the draft that at Article 6, officers of the board. I don't know how this slipped by me, but as our draft says that in Article 6, Section 1, that the chair would be elected by the members of the board, but that the chair would appoint other members, other officers. And that's never been our practice. So I move that the draft of the bylaws be approved with the following amendment to Section 1 of Article 6. The officers of the board shall be chair, first vice chair, second vice chair, and secretary. The officers shall be elected from the membership of the board, period, and strike the rest of that section.
Okay, you've heard the report from the bylaw board member Brown, and do I get a motion to accept the bylaw with the necessary correction? All in favor say aye. Aye. All opposed? Okay, the motion carries, so we will accept this as a
And
bylaw. with
I
the
will
nec-
say, Chair, I'm not sure if I heard the motion, but I probably missed it.
The motion,
I understood what the motion was. Did anyone make a motion? Okay.
made the motion.
Okay, and it was,
we made the motion with the necessary correction.
thank you.
Everybody, the motion passes, okay?
Okay.
Thank you. Give me a hard time, okay?
Just to be clear, who made the, I know Brown made the motion and seconded.
Alicia, you
I
know, she second, yeah. Do we need to play it back on the camera? Now, I want to make sure we're correct now. Thank you. The next item is the letter of the mayor, MPD, 61-page complaint, if you have any information on that.
We do have an update on that agenda item. Shortly after our executive committee meeting, the following morning, I met Director Dietz at his office and discussed this issue and discussed the board's concern with what is now a 14-month-long investigation plus. Hundreds of thousands of dollars have been spent, and there's no update, and reiterated that we're not asking for a substantive update, not to understand any findings. And Director Dietz seemed to take that seriously, and he followed up with a letter addressing our July 30th letter, where he writes, "Dear Chair Holloway, Mayor O'Connell asked me to respond to your letter sent to him in care of my office. At the outset, let me share the mayor's frustration over the length of time that has passed since engaging Ed Stanton and Butler Snow firm to conduct an independent investigation of the Garrett Davidson complaint. While I share that frustration, I do not believe the delay is anyone's fault. The criminal case against Mr. Davidson required conversations with the district attorney to assure Butler Snow unrestricted access to documents and witnesses while not interfering with the prosecution for alleged conduct unrelated to Mr. Davidson's complaint. The district attorney has participated in these discussions, and they have been fruitful. While I have not had substantive conversations with the Butler Snow attorneys about their findings, it is my understanding that the investigation has continued to proceed over recent months and is nearing conclusion. Please let Mayor O'Connell know if you have any ongoing questions or concerns. Sincerely, Wallace Dietz."
You heard the response from the mayor's office. Any comments from any board members? We definitely want to make sure this letter is also included in our file, because you never know what may come up in the future, whether it be in a court proceeding. And,
Absolutely.
you want that? Okay. So you never know what may come up in the proceeding. So you want to dot all your I and cross all your T. And this letter is just trying to cover their backs. That's all they're trying to do. and it's not anything that we can be pleased about, but generally they did respond, you know, they did respond. Okay. Do we get a motion to accept this report, this letter from the mayor and the report about the 6-1 page?
So moved.
Do I get a second? Do I get a second? Okay. You heard the motion. We got a second. All in favor say aye.
Aye.
Anybody opposed? Okay. Next item on our agenda is, let's see what it is, 26 goals and objectives. Do we have anything on that, where we stand on that?
Oh, no, I mean, I just included that. You guys, I gave you a copy of it.
Okay.
If you have any questions and you want to talk to me a little bit later about that, you can. I think it's really self-explanatory.
Any board member have any question concerning that? Okay, let's move forward on to the next item on the agenda. Executive Director Merit Increase Update.
I'll just say that the letter that was sent to the mayor, he responded. I made certain, and he sent that letter to you all. I don't really have any other comment about that.
Any comment from the board? Okay. Well, my thing is, you really have to sometime compare your position with other personnel or your status in other departments. And you have to compare men's with women and see, are they pretty accurate? Are they in comparison? Are they somewhat similar? And if they're not, it carries a heavier weight. And that's what I think we talk about at the executive board meeting, you know, and maybe a little time consuming, but it's worth a while. And so from this point on, we would like to have some information on that. At least I prefer you getting the information so you have something to fight back with.
Okay, I will do.
Okay.
Thank you.
Do we have any public comments at this time?
No.
Is our captain in here? Can you come forward, please? I don't know if you have the answer to me now, but maybe you can check when you go back to work and maybe send an email out to me or Jill. I would like to know when was the last class that graduated from the police academy and the number. I'd like to know if there are classes out there now. If not, when will be the next class?
Okay.
Maybe the academy can give some information on, or you check with personnel that does the recruitment and stuff. In recruitment, they should have an idea of whether they got another class coming out, where they stand on that. We don't want to. This city is growing too fast. Number one, we're getting hundreds of people moving here almost on a daily basis, and I prefer feeling comfortable that we have the staff to protect the city. At one time, we were probably 300-some people, officers short. And it's hard to keep up when you got people constantly retiring or people moving to other industry. You know, we have to compete with other industry for its pay grade. You know, what the police department make, probably you can make that or more working for someone else. And you got to go by all these rules and laws and regulations, you know. And I just like to know, see how we stand or how you doing your recruitment. It seemed to be that it's hard to recruit, but if you ain't really looking for nobody, how can you find somebody? You have all these universities around here with kids graduating, looking for jobs. And you don't have to go out to the city to recruit. So if you can get the information to me, I appreciate it. That's all I need to know. Or if you have some ideas now, if we've already had a class, you can present it.
Do you know how many people the department is short when it comes to staff? I'm sworn staff.
So prior to this newest round of our fiscal year, with the improvement that we received with the employees, we were on track to be under 100 below, short of what we needed. And that's actually pretty much considered to be fairly close to fully staffed in the fact that we try to run 8 academy classes a year. And that's between about, I think we typically do 4 basic and 4 lateral. But in order to be able to hire for the training academy, we have to have the vacancies in order to hire. And the process takes about a year, for it to go from being hired, starting the academy, and actually counting as a police officer out on the street. So we always have to have vacancies in order to hire, because our trainees are not counted in what our numbers are that we produce for the department. So we could show 100 vacancies, but have 75, officer trainees in the academy, or as PO1s riding with FTOs that don't count yet towards our numbers. So we have had an increase in our numbers, and we're working to fill those. I know our background in recruitment is constantly doing different recruiting events to try to attract people to Nashville, and going and doing all sorts of things within the community as well as outside of the community to try to draw people to the city. We are a melting pot, and so we want everybody that would be interested and be of value to the city to consider us.
When was the last class that graduated from the academy? What month was that? Was it this year, last year, what?
Last month, I think.
Yeah, I was gonna say, we just had a graduation about a month ago, and that combined, we combine graduations as well. So it was a basic and a lateral that we did the graduation ceremony for. So we were celebrating 2 graduations in one, which is typical of most of the graduations now that we do.
How many FTEs sworn total do we have? Is it 2,000? The last I heard it was like maybe 1,400, but has that number changed?
Yes, I would have to double check
Okay.
on the exact number on that, and I could get that for you. Especially, I want to take into consideration what we were given with this new fiscal year.
Okay.
Board member, Alicia?
How many, well, you may know this and you may not. If you don't, would you please bring this information back? How many women are on the force? Because I know you have the 30 by 30, which is 30% women by 2030. So I would like to know where we are with women being on the force and officers of color. Thank you.
Absolutely. I want to say the last time I was aware we were at 12%, but I don't know how that articulates the bare numbers.
I guess my question on piggybacking on that is is there a specific recruitment strategy around the hiring of women that you guys might be working towards?
I know we try to make sure to promote when Mayor Megan Barry was in office, the paid family leave that she implemented. I know that we really tried to put that out there and make that known and aware for women, as that's a huge thing when it comes to looking at having a family and taking that into consideration on that not hurting your time in the department, as well as being able to take off the time that you want for maternity leave. And so we do a lot of trying to bring that to everyone's knowledge when we're out recruiting, as well as discussing all the opportunities that there are within the department, the mobility that we have as far as upward mobility, as well as across the board to different areas of the department, and the flexibility that the department in certain areas can offer to trying to deal with primary caregivers, women in the department wanting to also balance family and work. So we do a lot to try to help facilitate that within reason and within the ability of each detail to take that into consideration.
Board member Sean, you have questions?
Yeah, so does MMPD still do the mobile diversity sessions during the
training
academy?
I believe so, yes. I know that they even I'm pretty sure they take a field trip as well to,
I don't know. They had, now, I don't
Yeah.
know. Now, I knew that they had that and they stopped it. And I'm not sure if they started it back.
I'll
but,
check. I
yeah,
can check
if you
on
could check
that,
on that, that'd be
definitely.
great.
Yeah, I was just gonna say, I remember that they stopped it. I didn't know if it was something that was re-implemented, but I think it would be good to have some sort of interaction with the board and the those going through the academy. So that's something that I think is super important. So if you could take that back, that'd be appreciated.
We used to, I keep saying we used to do this, we used to do that, but at one point, we, the agency was invited to go to the recruitment, to the police academy, training academy, and talk about the work that we do. And so we would send our, whatever you call that, but whatever, we would send them our curriculum or whatever you want to call it, and then it was a like a lesson plan, and we would cover the work that we do, the history of the CRB, what does it look like to facilitate to go through the process of a complaint and that kind of stuff. But that's been I would say that stopped sometime in like maybe 2022.
And was there a reason given for why that was stopped? Okay.
I have no idea.
Well, we can get it started back. It's called mutual understanding.
That's right.
Whoever on the committee of mutual understanding, you need to bring that up and get back with us on that. See what can be done. Because we want to keep an open dialogue between the police department and this organization.
That's right.
Thank you so much.
Yeah, absolutely. I'll work on these and then I will send Director Fitchard an email that she can then disperse. to
Sound
everyone.
good. Thank you.
Yes, thank you.
Now, what we have here is the NCRB case review.
Yes, I know that we put down, I wanted to tell you that CC 2024-092, after reviewing that case, it was not complete. There were some things that we needed to request, so it'll be presented next month.
Could you
because
repeat the number
There
again?
was something in there. So I told you that's an update to that.
Repeat the number again for me.
2024-092. No,
Okay.
I'm sorry. 2024-043. I'm sorry.
Okay.
It was 43.
I had a check mark by it. That's the reason why I asked you.
Right.
to
I'm
repeat it.
sorry. It was
No problem.
2024-043.
We're all on the same page.
Appreciate it. Thank you.
And we'll take the cases as you present them.
All right. We're gonna make, okay. Kim, you want to present your two first? Dr. Kim?
Good afternoon. I will be presenting NCRB case number CC 2024-023. And the allegations of misconduct by NCRB were against Detective Matthew Turpa for deficient or inefficient performance of duties. And these are the summary of the complaint allegations. On December 27, 2023, Ms. Jamie Maxim, hereinafter referred to as complainant, visited the Family Safety Center in Nashville to seek assistance in filing a report against her ex-fiancé and his father, alleging harassment, vehicular intimidation, theft, and unauthorized access to her accounts. She met with Detective Matthew Turpa, hereinafter referred to as Detective, and presented supporting evidence and explained the incidents. Detective determined that the information was insufficient or to initiate a report. During their meeting, he briefly stepped away to take a phone call, and upon returning, the detective assured complainant that he would follow up with her. As of February 20th, 2024, the complainant had not received any further communication from the detective. She contacted the Nashville Community Review Board to file a complaint regarding his lack of action. Upon checking the MNPD records, she discovered that no report had been filed. The complainant expressed frustration, interpreting that the detective's handling of the matter as an effort to gather information without a genuine intent to provide assistance. And so regarding that summary, the OPA investigation's findings are as such. On March 4th of 2024, the OPA received a complaint from the Nashville Community Review Board. And basically Sergeant Woosley made several attempts to contact the complainant and eventually met with her on March 26th. During their interview, the complainant alleged that the detective failed to complete reports regarding her stolen iPad prior to a stalking incident and separate incident in which her ex-fiance and father followed her. She stated the detective told her that he would follow up, but never did. Attempts to find body-worn camera footage and a call for service from the relevant date were unsuccessful. On April 24th, Detective Natalie Robinson made multiple unsuccessful contacts to the complainant. And also on May 1st, 2024, to confirm the details and her correct contact information. On the same day, she sent written questions to the detective involved. Detective later responded with additional follow-up. Detective Robinson noted MMPD policy requires an incident report only when an incident involves domestic partners. Based on the detective's written statement, the allegations involved an individual who did not meet the domestic-related criteria. Therefore, a report was not required. After reviewing both parties' statements, Detective Robinson found no policy violation. She also determined that the available evidence was insufficient to confirm or refute whether complainant had specifically requested an incident report, and it could not be established whether the matter was a domestic-related one. So based on that information, the OPA conclusions and actions were that in view of the foregoing set of facts and circumstances, the following recommendations are made regarding potential policy violations by the detective. The first one being the MNPD Manual 4.20.040, personal behavior, adherence to policy and rules of the Metropolitan government. To wit, MMPD Manual 15.50.030, documentation of incident and departmental record keeping. And for that, the recommendation was not sustained. Also, number 2, the MMPD Manual 04.20.040, personal behavior, adherence to policy and rules of the Metro government. To wit, Metro Manual, the MMPD Manual 15.30.20, follow-up investigative responsibility, was also not sustained. So overall, with the NCRB conclusion, there were several rules that were not followed. An interview recording was initially missing from the investigative records. A required body-worn camera recording was not made. An incident report that should have been completed was omitted, and a follow-up investigation that might have filled in the gaps did not occur. These lapses likely hampered comprehensive documentation and delayed oversight review and may have affected both transparency and complainant safety. So after a review of this particular case, the NCR recommendation is that the Assistant Director recommends that the OPA investigation be referred to OPA for further investigation. And I'll point out that the AD and the ED did confer on this matter. Also, it is further recommended that OPA review NCRB's allegation for deficient or inefficient performance of duties, as the detective failed to document and activate his body-worn camera when the complainant requested to report an incident. NCRB believes that the allegation should have been sustained. MMPD leadership should review this case as an example to reinforce internal policy compliance, improve officer accountability, and enhance victim protection. Additionally, it is recommended that detectives should receive more training geared to domestic violence and sensitivity. And we further recommend that the recommendation be sent to the board and the chief.
Okay.
And the mayor. That concludes my report.
Okay, you've heard the report. Are there any questions, comments from the board member? Okay, since there's no, you got a comment?
I was at a motion.
Okay, we'll get a motion to accept the report.
I move that we accept the report, and I think the assistant director's report is very thorough, and I'm particularly concerned that we emphasize that the importance of the body-worn camera. That would have made this a lot simpler. But I move adoption of the report.
Do we get a second?
I second.
All in favor say aye. Anybody opposed? Motion passes. All right, we'll go with the next report. What up, please?
Is that 33? Is that yours? All right, I'm going, it's 2024 CC 2024-033. Our lead compliance monitor, Miss Amy Simmons, is going to present that case.
Okay, again, this is CC 2024-033. Allegations of misconduct by NCRB against Officer Alexandra Herring, adherence to policy and rules, and honesty and truthfulness. Summary of the complaint allegations. On March the 26th, 2024, the complainant, Mr. Chris Baumgartner, hereafter referred to as complainant, submitted a complaint to NCRB. He alleged on February the 5th, 2024, that MENPD Officer Alexandra Herring, hereafter referred to as officer, made key administrative errors, failed to provide accurate information, failed to reconcile statements with physical on-scene evidence, and lacked attention to detail as she responded to a crash collision at the intersection of Granny White Pike. The complainant's former spouse, who was listed on the crash report as driver 1, was involved in a collision which resulted in total loss of both her vehicle and the other driver's vehicle, which is driver 2. The complainant expressed his dissatisfaction with the officer. He stated that she relied on a witness statement, who was witness 1, who was recorded stating that he did not directly witness the accident. There were also inconsistencies with the initial and subsequent reports filed on February the 6th, February the 7th, and March the 24th of 2024. The noted discrepancies encompass failure to account for traffic signals, discrepancies in witness testimonies, misrepresentation of the direction of travel, and misidentification of the sides involved in the collision of the vehicles. The complainant made efforts to address the concerns by seeking a resolution with Sergeant Scott Hull, who will be referred to as Sergeant. The complainant also expressed concern that no statement was obtained from his ex-wife. The information in the officer's report was damaging and placed prejudice on the determination of fault. Okay. There was no mediation offered. OPA investigative findings. The complaint was referred to OPA on April 12th, 2024, and was assigned to Detective Randy Hines. OPA completed its investigation and was received by NCRB on June the 20th, 2024. On May the 24th, 2024, Sergeant was interviewed as a witness by Detective Hines at OPA. A review of officer's body-worn camera revealed that she did not ask either driver what occurred. Instead, the officer took the statements of a witness while one of the drivers listened to the witness statement and nodded her head as though she might be in agreement. The other driver was not as close and did not seem to indicate hearing what the witness stated in her interview with OPA. The officer agreed that part of the investigation into the traffic crash included taking statements from the drivers, and that she did not ask the drivers what occurred while on scene. There were several other issues related to the first 2 accident reports, which were corrected by officer prior to the complaint being received by OPA. These had been corrected on the officer's 3rd report on March the 26th, 2024. This was due to the complainant having called the sergeant and identifying the issues in the accident report. The sergeant then had the officer to correct the report and resubmit it, which ended up being the 3rd report submitted on March the 26th. The incident was referred to MENPD Traffic Division. Detective Chrissy Priel completed a supplement to the accident report, which concluded her investigations and findings. NCRB review. The NCRB review of OPA's investigation and body-worn camera video revealed the officer responded to the traffic collision on February the 5th, 2024. The complainant's former spouse, driver one, was one of the parties involved in the crash. In their interviews with OPA, both officer and sergeant confirmed inaccuracies within the officer's report. Such inaccuracies included incorrect personal information and the incorrect location of the accident. The officer agreed that part of the investigation into the traffic crash did include taking statements from both drivers, and she did not ask the drivers what occurred while she was on the scene. The sergeant also mentioned that the officer did not activate her body-worn camera as she should have. The officer's body-worn camera confirmed she did not speak with the drivers on the scene of this accident. The officer instead typed up a crash report based solely on the statement from a witness who admitted he did not observe the crash and received his information from another source who was not interviewed. The officer never asked driver one or two for their version of the event. OPA's conclusion and actions. In view of the foregoing set of facts and circumstances, the following recommendations are made regarding potential policy violations by officer. MENPD Manual 4.20.040, personal behavior. A, adherence to policy and rules of the Metropolitan government. To wit, MENPD Manual 18.20.020, traffic crash response, investigating and reporting. First, officer at crash scene responsibilities, locating witnesses and recording crash information. Recommendation is sustained. NCRB conclusion. The OPA investigation is satisfactory and complete, and recommendations should be considered. NCRB recommended action. The executive director and lead compliance monitor conferred, and these are the recommendations. Officers should receive training on preliminary investigations and traffic crash documentation. Officers should receive training on activating the body-worn camera, in-car camera, consistent with MENPD's policy to record any investigative or law enforcement activity involving a member of the public. Sergeant Hull mentioned in his interview that with OPA that officer did not activate her body-worn camera as she should have, and this action did not receive any form of corrective action. The executive director recommends the board accept the report and send it to the chief of police and the mayor. And that's it.
All right, you've heard the report. Do we have any comments? All right, do we get a motion to accept? Do we have a second?
Second.
Okay, it's been motion properly given and second, so all in favor say aye. Anybody opposed? All right, the motion passes. Thank you, and we are ready for the next.
Okay, thank you. This one is NCRB CC 2024-092, the allegations of misconduct against Officer Zachariah J. Souza. Number one, conduct unbecoming, courtesy, discrimination, honesty and truthfulness, harassment, and bias-based policing. The summary of complaint allegations is Ms. Emma Shelton, hereinafter referred to as the complainant, made a complaint to the NCRB on December 30th, 2024, alleging that Officer Souza, will be hereinafter referred to as officer, interrogated her about a traffic incident involving a hit and run that she was not involved in. The complainant states that the officer confronted her in a local business where patrons were present and embarrassed, intimidated, and bullied her. She believes the officer racially profiled her and another male patron because of their race. Both are black. The complainant stated that the officer approached her and asked if she was driving a white Malibu, and she advised that she was driving a white Lexus. He then spoke to another person who stated that he was the owner of a white Malibu. The officer then took him outside and spoke discreetly to him. When the officer returned to the business, he approached the complainant, asked her more questions related to the traffic incident involving a pedestrian And she became agitated, and she says that she unleashed on the officer because of his treatment towards her. She relates that she has never had a negative encounter at MMPD before this exchange, and this exchange changed her perception. She stated that she would like the officer to be fully disciplined for his bullying behavior and attitude, and the complainant also requested that the complaint be placed in his personnel file. So the allegation, all the evidence was reviewed. I relied heavily on the body-worn camera footage and the officer's testimony through witness interviews, of course, and the witnesses, the complainant. So the OPA's investigative findings is that they received a complaint through Hub Nashville. They also received a complaint directly through us. And Sergeant Ted Woosley, he reported that he reviewed the officer's body-worn camera footage, that the officer responded to 3311 Gallatin Pike for a call for service. The call was about a possible hit and run where a pedestrian was struck in front of a Kroger's, and that the clerk of the store was present. He says that he was present and he witnessed this. He then goes on and says that now this is in a 911 call. And so it's not clear on whether the officers had that information initially when this happened. But what the store clerk does is at some point, the timeline became tricky. And he says that he followed this vehicle, which was a silver Malibu. And it went down Gallatin Road, turned right on Trinity Lane, went to his other store, and then I guess switched cars and then came to this particular pawn shop. It was a very incredible story. And so as he was talking to the officers, when the officers arrived, this complainant is in the store trying to conduct business, as was multiple people. And so the clerk is talking to the officers outside and kind of saying, this is the woman, I saw her hit a pedestrian and now she's in the store. So the officer, of course, comes in and he approaches the woman because the clerk goes back in, and the clerk is conducting the interview. He's making the first initial contact, and he says, he says the complainant's name. He says, these gentlemen need to speak to you. And of course, she's genuinely surprised, and she says, me? Why? What is this about? And then the complainant was asked, does she have a white Malibu? And she replied she didn't have a white Malibu, that she was in a white Lexus. And so another patron who is standing near her says, I drive a white Malibu. And so they all go outside, they inspect his vehicle, and while they're inspecting his vehicle, of course, there's no issues. And he says, I've been here since I saw the accident. When I pulled up, I saw, emergency vehicles out there. And so then the officers kind of discuss this, and then they go back inside. And once they go back inside, the clerk is now in the back talking to two officers who are kind of, one is a trainee and one is a fairly new officer. And they're discussing what the clerk is saying. And the clerk is saying, no, I saw her. She was driving it. I followed behind her. I called dispatch. I told them. And so this goes on, and they're getting all of this information from the clerk. All right. And so the clerk is adamant that this is the woman. And so when the officer, of course, approaches her again and starts talking to her about the case, she is clearly agitated because she says, I went to Kroger's. The only place I've been is to Kroger. I left my house, I went to Kroger's, and then I came here. I don't know anything about an accident, never saw anything like that. So this kind of back and forth goes on for a little while. And the employee, she's not aware that the employee is the one that's making the report. And so it seems like there's some miscommunication The officers then go back outside, discuss this situation, and then finally realize that the tag numbers don't match. There's no silver Malibu, but they're not fixated on silver, even though the gentleman said it was a silver Malibu. They're focused on this white Malibu that it's not happening. There's nothing that relates to a white Malibu. The tag number, there's not a white Malibu in the parking lot. And so it seemed like they just at some point realized that there wasn't much that they could do. They were doing the pre-investigation. They were going to turn this information over to the crash unit to handle. And so I felt that the report was, OPA did a good job in following up with everything that they could have. The issue here, my recommendations, as you'll see, is that the inconsistencies in the reporting came from a witness. If there was anything that needed to happen with OPA is that they did not interview that witness to get a clear timeline. If he said that he followed a silver Malibu and he did all these things, the whole issue was he is thinking that this woman went and switched cars and then came to his business. And there was nothing to validate that or support that. And so my recommendation is that the field training officers receive additional pre-investigative training related to witness interviews. And I will say what I put in this report says the officers named in this complaint should receive additional training related to pre-investigation witness interviews. During the review of the investigation, it became apparent that the information that was provided to the officers by the pawn shop employee was inconsistent and did not support his allegation that the complainant was the driver of a silver or a white Malibu that hit a pedestrian and kept going. Secondly, the employee gave officers a license tag number that did not match the complainant's vehicle that she drove to the pawn shop and did not match another vehicle that she owned or any vehicle on the property. It is also noted that she readily shared the information about the other vehicle with the officer, didn't seem deceitful or hiding any information. The store employee told the officers multiple times that he witnessed a silver Malibu strike a pedestrian and not stop. He stated that he shared that information with dispatch and followed the vehicle to the other pawn shop. He believed that the complainant was driving that vehicle, left the scene of the accident to switch cars, and then showed up at the pawn shop in a white Malibu. Remember that pawn shop is directly across the street from where the hit and run happened. The complainant was not driving a white Malibu. She was driving a white Lexus. There wasn't any mention by the three officers of a search for a silver vehicle. The inconsistent information provided to the officers by the employee should have prompted a more thorough interview with the employee to determine if they had enough information before questioning patrons about a very serious allegation of hitting a pedestrian with a car not stopping to provide aid. And officers should take into consideration the location and proximity to others when they are questioning individuals or witnesses about potential crimes. Speaking to an individual in a store filled with patrons is not ideal and can escalate from a sensitive discussion to a very hostile, critical, or dangerous situation. And I will go back to, in her formal complaint, she stated that she unleashed her voice on the officer. However, her tone was really slightly elevated, indirect, as she expressed her displeasure. It wasn't loud, it wasn't boisterous, there was no profanity. It was just very direct, and it was, I'm gonna report you. So that was it. And so that concludes my investigation and my reporting on this case. And so I'll take any questions.
You heard the director report. Are there any questions? Any comments? Get a motion to accept? Brian, you got a
I
question?
make a motion to accept, and I once again point out the body-worn cameras are really a bright light on these complaints and make everybody's job easier. I move acceptance.
Do we get a second? Okay, there's been a motion made and probably second. All in favor say aye. Aye. Anybody opposed? Motion passes. Thank you.
Thank you.
Next report.
I think that concludes all of the reporting for today. Oh, I'm sorry. That's right. How did I go before you?
014 was that supposed to go today?
No, I'm sorry. I was supposed to go last, and so we had one more, 2025-014.
Yes, correct. I will be presenting NCRB 2025-014 and the allegations of misconduct by NCRB against Officer Ruben Mariano are adherence to policy and rules, conduct unbecoming of an employee of the department, responsibility, deficient or inefficient performance of duties, and adherence to law. And the summary of the complaint allegations reads as such. On February 27th, 2025, at approximately 9:30 a.m., Mr. Chris Hicks, hereinafter referred to as complainant, traveled westbound on Interstate 24 with his riding companions when he encountered a marked MMPD SUV rapidly approaching him from behind. To avoid being tailgated, the complainant accelerated and changed lanes to allow the vehicle to pass. Officer Ruben Mariano, hereinafter referred to as officer, swerved in behind him and continued to follow at close range. As traffic progressed, complainant slowed his speed, but the officer maintained close proximity before he eventually swerved around his vehicle and accelerated to an estimated speed that exceeded 80 miles per hour. Officer proceeded to weave through traffic at a high rate of speed. He tailgated other drivers as well. Complainant identified the vehicle as a large white MMPD SUV with distinguished police markings. Complainant expressed concern that the officer driving behavior demonstrated aggressive and unsafe conduct, which is characterized as road rage. He described the actions as unprofessional and unacceptable, stating that disciplinary action should be pursued. And again, there was no mediation offered in this case. As to the OPA investigation findings, on March 6th of 2025, as a part of the preliminary investigation, Sergeant Woosley reviewed the TrackStar data for the vehicle that the officer drove. The TrackStar data indicated that the vehicle exceeded the speed limit multiple times and crossed from Tennessee into Kentucky. Sergeant Woosley stated that during the preliminary investigation, it was unclear whether the officer was on duty or had permission to leave the state, or why he was operating in that area. Email communications later stated that the officer was in the area for recruitment purposes. Before the investigation concluded, officer agreed to a pre-investigative settlement. Officer accepted responsibility for speeding and agreed to a first offense Category E written reprimand. As a result, no recommendations were made by OPA, as a recommendation summary would be a part of the case summary. Sergeant Woosley also noted that although additional allegations were listed by NCRB, the identified policy violation was deemed appropriate and consistent with MMPD manual, which is 4.10.40, determining the appropriate charge. As to the NCRB review, the investigation verified through GPS data and dash cam review that the officer drove excessive speeds up to 93 miles per hour on 2 occasions during his commute to Kentucky. While the dash cam video confirmed speeding, it showed no evidence of tailgating or unsafe proximity to other vehicles. Officer accepted responsibility through a pre-investigative settlement and was issued a written reprimand as his first offense with no prior or similar disciplinary history. As to the OPA conclusions and actions against the officer, number 1 was the MMP Manual 4.20.040, personal behavior, adherence to policy and rules for metropolitan government, adherence to law. 2 with TCA 55-8-152, which is the speed limits. Prior to the conclusion of the investigation, the officer, again, he agreed to the pre-investigative settlement. NCRB conclusion is that the recommendation, NCRB recommends that in cases where the officer's behavior rises to a level of endangering lives, the discipline should be explicitly for reckless driving instead of less severe charge of speeding. And so the NCRB proposes stronger reprimands that correspond more accurately to the nature and seriousness of the offending conduct. And so the final action and recommendation is that this be sent to the board, of course, and accepted by the board, and then sent to the police and mayor, and the AD conferred with the ED regarding these actions. And that concludes the report.
And just one note here, this officer was driving 93 miles an hour. And if that was you or me or anyone else, we would have received a reckless driving, and lost your license. I just wanted to be very clear about that.
Board Member Heather.
Thank you. Yeah, I have a couple questions on this one. First, just want to preface by, we're required by statutes to do the police academy. As a part of that, I did a ride-along, which I've shared with many of you, some of my experiences, but specific to this case and my experience on the ride-along, there were two instances, one where we hit 80 plus miles on Gallatin at 3:30 p.m., jam-packed traffic, where traffic was dead stopped and we were gunning it towards people. Like, it was reckless. It was pretty scary. Then there was another moment where we hit 100 on Ellington. Now, mind you, our lights were on both times, but this seemed very egregious. And so my first question, and obviously a policy violation, but my first question is, do these infractions, and this might be a question for, forgive me, is it Lieutenant Cantrell? Captain, okay, I will learn that. Captain, and my first question is, do these infractions increase categories of the offense with multiple or subsequent? Like if this is now on his record as a written reprimand for speeding, if he gets a second one, is that going to increase the category of the offense and potential punishment?
So we have our disciplinary grid as part of the manual, which you can actually access through Metro Nashville's website. And that will break down categories and offenses. So like a first offense, second offense, third offense, as well as a retention period for each category. So depending on when the second incident occurs compared to when the first one occurred, if it's outside of that retention period, then it can be treated as a first again. If it's within the retention period, then it can be treated either as a second offense or subsequent offense, as well as being increased in category depending on the specifics of the situation.
Heather?
Thank you, Chair, and thank you for that. I just pulled up the manual. I haven't had time to go through it, the disciplinary grids, but I will look at that.
Yes.
And my second question, there's no body-worn camera on this incident, or at least there was none turned over. I'm assuming that's because lights weren't on and he was just speeding, so there wouldn't have been any body cam footage activated, correct?
Yes, ma'am, there is body-worn camera footage. There happened to be another officer behind, and they retrieved that body camera, and I did view it.
Oh.
So I can see the officer going at excessive speed. However, at the time that I looked at the video and the things that I saw, I didn't necessarily see him actually right on someone's tail, like tailgating. But I did see the speeding, the changing lanes, and then it's a very short video, but there is body-worn camera footage on this. Yes, ma'am.
From another.
Correct.
And when Trackstar caught the body cam footage, but Trackstar doesn't give any kind of notification to the department if an officer is reaching a certain speed, does it? Without lights on, without a call?
I would have to check on that.
Okay.
Let me say this. When I was on, they had something called a tachograph. It recorded your speed, where the car was running, where you had an emergency. Before I left, it got to come to AVL. It was a satellite thing that record how fast you were going, and it can almost pinpoint to the exact location where you are. You know, it's not 100% because it had me out somewhere. I was in court on trial. But basically, they can look at the AVL and tell what you're doing, how you're traveling, and the dispatch can notify the supervisor on that as well. Board Member Brazil.
Yeah, just a question. Member Michelle, when you relayed that, this was not in a pursuit type situation?
Correct. Neither of those incidences were in a pursuit. We did have 6 calls that night, or 6 codes that came across that required flipping the lights and hitting really high speeds, which I think was a policy violation, but I'm not here to knock on anybody or anything, but no, they were not in pursuit of anyone. They were in response to calls.
Okay, thank you.
Board Member Brown.
I have a question. As I understand our charter, we can't recommend.
Okay.
Did you need something? Sorry.
Oh, as I understand our charter, we can't recommend increased punishment. I think we might need to change the language there at section 10 at the end. The NCRB recommends that in the future, because I don't believe we can recommend increased punishments. So I think that would clear that. I certainly agree with the report, and 93 would scare the devil out of me, much less 100.
And then I just want to remind you that like a couple of months ago, we had 2 cases that were similar to this with speeding, where officers were traveling into Nashville from outside of the county. We had 2 cases like that, and they were traveling in 80, 85 miles per hour. And then the punishment on those cases was also they did a what do they call that? A pre-investigative settlement. And what that does is that is basically no discipline, really. And just like if you look at this grid, you will see that written reprimands, if you see like verbals and things of that nature, really aren't even discipline. And so we have officers, and the person that reported those cases lived in those areas and followed them all the way into Nashville, and they were going that kind of, speed, as well as shifting lanes without putting on their blinkers and things of that nature. And so if you want, and when we think about the cause and effect of that and what could have occurred, and that if that was a civilian doing that, then there would have been, a more severe punishment for that. So that would have been costly.
One problem you've got, this complainant apparently followed him from a good distance. What speed was the person?
Well, the complainant said that he
excuse
was
the police
headed
officers.
into the city anyway.
Yeah.
So, yeah.
Yeah, it's a little bit of a concern. Unfortunately, if you drive on the interstate at the legal speed limit, you're going to get run over.
What you do in
But
Kentucky
90
is
is-
fine, but
90
when you
is-
get into
93
Nashville,
is- That's way above.
Yeah.
This chart here was designed when I was on the force. I was with a group of people, the FOP president, Chief Anderson, and I think the FOP and I, president and I, was the only one disagreed at first, but what it's boiled down to in the final analysis, I'm the only one that struck back against that process. The process was designed for individuals to look to see themselves what kind of category they fall in, according to the disciplinary procedure. And I say it's a good design provided that if it's done properly. And they said, what you mean by that? Because you could have a good old boy you want to save, you know, and that's out the window. The rules ain't for everybody, you know. But anyway.
Also, just as a reminder, when you look at it, I don't know how they, and it's something that we should look into. Those suspension days are, they're not suspensions. You can use your vacation time in lieu of a suspension.
Board Member Heather, you got a comment?
Yeah, I'm sorry. If someone could help me understand this, I was trying to look on the documents what category of that offense was, the speeding or whatever this officer agreed to. So if that's a category F.
So traffic, like speeding is a minimum category E.
Minimum category. Okay, minimum, thank you. Minimum category E. And so for a second category E offense, let's say 2 months later, this officer was speeding 93 on a street and someone called it in or filed a report. Would that still be a category E, or does that escalate as a subsequent and like compounding offense?
Depending on the circumstances, you would typically move to second offense. But if there
Oh, second offense, okay.
If there were aggravating
I see.
circumstances or mitigating, then as long as you can justify it, there can be movement within the chart,
Okay.
but there has to be reasons.
Sorry, I see second offense up there. Thank you.
Okay, you've heard the report and we made comments. I do have a motion.
So moved.
All right, and do we have a second? Okay, there's been a motion been made and been properly second. All in favor say aye. Aye. Anybody opposed? Thank you.
And this is with the added language. Did you all agree to that language that Member Brown? Okay.
Okay, I think y'all are so kind. I wish you had been in place when I was coming on 30 years ago. I probably wouldn't get all my suspension. But anyway, you done a great job, and I appreciate it. And I think we had a great meeting today and in a good location, you know. And so we just keep up good work as a team. Oh, boy.
Yeah,
New business.
But new business, I'm sorry.
Okay, go ahead.
So, Dr. Kim, your report on this investigation where the officer didn't believe it was a stalking case. I know I'm going back a bit, but I want to make sure I got this right. So it wasn't deferred to a property crimes detective. It was a report for stalking just wasn't made. Is that right?
Correct. There was no report made.
Okay.
The phone rang, he went away, and she says he never followed up. And upon checking, there was no evidence of any report made, and no evidence of body-worn camera footage, none of that.
So I wanted to offer this to the board and the staff. On my day job, this is a topic that I teach: response, investigation, and prevention of stalking, and for IECP and the Justice Department. So over a 2-year period, the Justice Department had a group of us design a national police response to stalking model policy. Mm-hmm. It's like 35 pages total. It's a complex crime to investigate. And we've been distributing it now around the country. And it's important because, for a lot of reasons, stalking is a pathway to murder. And for Nashville in particular, in the 80s and 90s when I worked in homicide, we looked at our murders here in Nashville. 80% of our domestic violence murders, the victim was stalked before the murder. Mm-hmm. The present national statistics are 82% of IPV, interpersonal violence murders, there's a stalking before the murder, which means it's preventable. That's the belief. So we've been giving to police departments this new model policy on stalking. I don't know that Metro needs one. I know when we wrote the DV policy here, we included stalking in the overall DV policy. I'm sure it's been amended since. But now that we have the opportunity, because we have a complaint before us on stalking, improper investigation of a stalking case, I wondered if I could send all of you all this model policy for review and to the research group at your office,
Sure,
Director Fisher.
absolutely.
because it's one of the most missed crimes in the country. It's interconnected, co-occurring with other crimes like this theft. Some agencies do a real good job of it. When I left, we were doing 30 cases a month here. I don't know what the numbers are now. But we had such success with the sexual misconduct policy as a recommendation. And this is a federal funded project to do this policy. I thought maybe I would submit it, and then I'll offer this last thing. We've been looking at statistics on this, and one of the test cities we looked at was Harris County, which is Houston. That's the fourth largest city in the country. And we looked at their 911 dispatch system, and they got, in this study that we reviewed and are using now, in 2015, it's a little bit dated, but they got 3,765 reports of stalking in this year period. 66 of those reports made it to a police report. 0 ended in prosecution. So it's a common problem with police departments of them not reviewing their success in prosecution and investigation. And it is a very specific focused crime because of cyber stalking and all the other things that are different today than they were when I was an investigator. So I wanted to send it to you all for review and maybe ask the department, have they done an internal review of their stalking cases? Because if you're looking at homicide prevention, that's where you go.
That's a good point. Do you know just off the top whether or not the law has been looked at and enhanced? You know, the Tennessee state law in the code.
Yeah, Tennessee state law. We worked on that when we got that passed, and it took us a while to get that passed through the legislature. Yeah. And it's been amended several times since then.
Okay. Good.
Online, offline. It's a real. Stalking policies have the same DNA around the country. I mean, they all look the same. It's following, 2 or more occasions, putting someone under substantial emotional distress. It's got a lot of elements, which means it's a much more complex in time crime to investigate for the police. It's not an incident, it's a course of conduct.
Right.
So there's a lot of complexity to it. But the law is organic, obviously, and it changes whenever there's a need that comes up around the state, around the country too. So, but I'd love to get your opinion on it, and maybe we can do what we did with the sexual misconduct policy and present it to the police department to see if they'd be interested in a standalone, not included into, but standalone policy for response, investigation, and prevention.
I would love that. I think that more people need to be educated on what stalking is. I think that a lot of victims don't really categorize certain types of behavior as criminal acts. And so I think that those two things go hand in hand, a policy possibly standalone and public education regarding it.
And it's not a policy that a group of people just got together and designed. We did a lot of research. Yeah. It took us 2 years to do it, and prosecutors were involved in it, and we've been giving it to police departments now around the country with some success, and they're implementing it now. So.
Well, we have seen an increase here in Nashville of domestic violence issues that have resulted in, the killing of a victim, and then that person who is the actual killer killing themselves. I mean, we had several of those happen back to back over the last year. So,
when you add stalking to lethality, it multiplies it up to 5 times. So the moment you start physically stalking someone who you're in a prior relationship with, their odds of being a homicide victim go up pretty incredibly high. So, and they know, the department knows this already, but I don't know whether they have this modern new police standard for stalking. So I'll send it all to you. Yeah.
Well, Chief Surpass had a thing where, when in doubt, do a report. So you have a paper trail and you follow up on it. So that was one of his main things. So, Brown, you have a motion or anything?
I have one matter before the motion to adjourn. It's on the aging report that we've gotten. My concern on it is it kind of makes us look bad and I think we need maybe to change some dates, because we've got a whole bunch of cases here that are 400 or 500 days old, but we show OPA investigation closed. We need to add in the date, because a lot of this delay is OPA, not us. But on the other hand, it looks like we've got several cases that have been under review for well over a year. And I think when we've got cases that are more than 6 months under review, we need to have some explanation for what it is. It may be body worn camera. I know our staff is very busy on it, but I think if somebody was criticizing us and they pull out this report, it makes us look bad when we're not.
No, absolutely. And this report is just, of course, a small snapshot. We have the huge report that kind of has all the explanations. And so we were trying to figure out how to make this as simple to give to you all. But we can always generate the big report for you so that you can see it.
My concern is this is a public record,
Right.
and somebody starts quoting from it.
Right. I
I'd
understand
like
that.
not to cut my own throat.
Okay, all right. I appreciate that. Yeah,
we'll try
to do is revisit how this looks.
Yeah,
in the
I'll be glad to
design.
work with you on it.
Okay, appreciate that.
Absent no other comments, Mr. Chair, I move we adjourn.
Board member held her hand up.
Thank you. Sorry, I have one more question, and this is a follow-up to our last meeting. One of the cases that we had, I was thinking about this earlier. It was a case where an officer had a lengthy disciplinary history and ended up resigning due to the most recent complaint. And then E.D. Fitchard made a great suggestion as a part of the report, which was to recommend post-decertification for that officer. And I was thinking about how that is important to ensure safety in the community when you have an officer with a lengthy history of infractions who's resigned and can simply just transfer to the next county. So my question is, how do we follow up on that recommendation? It's a pretty substantial recommendation, again, to ensure public safety. How do we follow up on that to see their response? Is that something that Captain Cantrell can follow up on, or is that something that we track separately? We don't make that recommendation every day, but it's a serious, substantial recommendation, and I just want to know if it follows through.
So I think that it falls under the same provisions and guidelines that the chief has 45 days to respond to that. And so for some reason, I think that we've only received one extension request, or not request, but to say, hey, we're needing more time on the cases. That's why I said I need to follow up and send all the cases with the dates and times that we've sent them to see where we are with those. Those were sent to the chief a couple of weeks ago after the meeting. So he has those. He acknowledged that he received those cases. And so, but we also have sent, more than a dozen cases and haven't gotten a response as of yet. So, but I do agree with you. That case was very important because of the consistent disciplinary actions of that officer. I think that it warranted a decertification. And so
maybe by next meeting, we'll know if there was any response. Can I just ask for some kind of follow-up from the board? I would just like to know how that goes with the chief and the mayor, and if any action is taken based on our recommendation.
Thank you.
Director Fitchard, the decertification process, I think, is written into the state code. If you wanted to dig that out, maybe, and share it with us.
Okay.
All those post requirements are
They're on there.
there. Yeah, they're. So anything that they do has to be, by the state law, like us. So.
And post, when they have these hearings, they have their commission there, and they do it publicly. They're all online. You can review them. I've went on and looked at them, and what I saw over the ones that I looked at pretty consistently was that MNPD wasn't represented much. I I think I went back almost 6 months or even further, and I didn't see cases where MNPD had decertified anyone. But I did see a lot of surrounding counties and counties from across the state.
You got other counties kind of take it kind of lightly when they see something like that. And
They're the ones going to post.
they seem to think that happened there. It's not going to happen here. But believe it or not, sometimes it can be a pattern in another city and also carry on into the next employment to another city. You know, but a lot of times they take the chances and hire them anyway, or either put them in a position where they probably shouldn't be working. You know, but you can give them a desk job or something like that. But when you're dealing with people, you have to be careful when you got some on your employment record, such as anything of that nature. You know, so but a lot of times people just trying to fill the vacancy and not worrying about it. It depends on who represent them, who they sponsor. You know, they can use a name, some captain, some lieutenant from another area saying, this is my boy, take care of him, you know. And it does happen, you know. Let's be for real, you know. But anyway, any more...
I just wanted to ask one more question. So, remember when I think your recommendation was spot on in terms of stalking and how that could lead to, homicide, murder. You know, we've seen that time and time again. We have seen it happen in Nashville where victims' families have now gone on to sue the city of Nashville because they've lost a loved one because of improper training or missing those signs that could have potentially prevented the death and harm of a citizen or in their case, a loved one. So since this report is going back to OPA, correct?
It's going to be amended, and then it goes to the chief, and then it goes alongside the mayor. That's what is how we send it.
And what was
Unless
the amendment?
you guys, because, so the board recommendations are accept and send to the MNPD chief of police and mayor, accept with modifications, reject and send back to staff. So we're going to accept it with modifications, and then it will be sent on to the chief and the mayor's office. It doesn't go back to OPA.
Okay. So with that, will the policy from IACP, right, be sent with that case? I'm trying to figure out where we are with that because it should live with what we were discussing.
Well, we could probably, if you guys want, I could say when I make this change to it, refer to the IACP policy on stalking as a recommendation for implementation or something like that. I prefer to do it the way that we talked about here, and not let it just be like that because
I don't want it to be. I don't want it to just. We're not going to put it in their hands, but kickstarting is what I'm saying, and initiating the conversation in terms of a stalking policy from IACP. So, do we attach it to? I'm just saying. Do we have an example for that?
Idea. Yeah, I don't think because this isn't. I think that changing it. I think that handling it the way that we discussed, which is taking out our board recommendation for discipline, and then
that's right,
is where we should leave it, and then move forward with having an independent opportunity to discuss a stalking policy.
Well, we're going to do that anyway, right? So that's going to happen. We don't. That's not what I'm saying. We're going to do that, but in terms of the actual case. And where we're referencing the stalking issue, like how it came about, is what I'm saying. So we're kickstarting the conversation, is what I mean. It's not that we're going to change the process or anything, or we're just going to leave it up to them to do it. We're going to follow through with the research and promote the policy.
Well, what you're requiring would need to take another vote.
Yeah, I know.
Yeah.
And by the way, let me say this: it's a strictly Justice Department project. IACP play a part in that. So it was funded by U.S. Department of Justice. So it's their policy, not ICP.
Okay.
So,
Sean, did you have something? I know.
What is there any value? I see what you're saying. Is there any value to doing them independently, and then when we do the second part of it, the way that we talked about it, referencing the case at that point?
Yes.
Okay.
So what I'm saying is, we're not just gonna take the case and send it back to the chief and the mayor, and it's like, okay, that was that case, but then now we have this talking. They're interconnected, if you will. So if we didn't have the case, we probably wouldn't be talking about this, is what I'm saying.
So what, okay, I think that I need, for a point of clarification, the case that we were changing, the recommendation was for the speeding, right? Which is the one that we decided, the speeding, that we said, if they were speeding, that they should get a charge with reckless driving. This other case that you guys are talking about was already accepted. You guys accepted that case without any changes to it. And then at the end, Mark just said in new business, hey, by the way, IACP has this stalking case. This case is not only about stalking, but it is about stalking. So this case was accepted the way that it was, and that is for the recommendations that you guys agreed to, right? Which is, let me go over those recommendations. And then this, of course, is, the recommendations were, I'm sorry, which one is it? Oh, here it is, right here in front of me. 023, okay. Under 023, the recommendations were, the assistant director, that OPA investigation be referred to OPA for further investigation? Is that one of your recommendations? To send this back to OPA? It's further recommended OPA review NCRB's allegation for deficient or inefficient performance of duties as a detective failed. So this is a case, and what the law says is that we would have to send this back to the chief and say this needs more investigation.
That is correct.
And so the chief is going to, so when it says OPA, that's what it is. We're sending it back for more investigation. Right. So that's what it says.
And we also spoke about receiving more training geared to domestic violence and sensitivity. That was also one of the recommendations. And also to, the recommendation was about the body-worn camera that was not activated. So that report was accepted, to my knowledge, with no amendments.
To go back to, for further investigation.
And with that, we're sending the policy report, if you will, however you want to call it, with this to OPA, because it's going back to them. And then that is let's, for lack of better terms, kickstarting the conversation in terms of how we go about with the.
But sending it to OPA means, I mean, they don't have it. They don't do anything.
No, they don't.
No,
they don't.
Whoever makes the policy is her department. Is with Captain Cantrell's department.
Captain Cantrell.
Right.
I'm not trying to go. I mean, it's not semantics. OPA. I'm just saying it's not going to the chief. It's going back for further investigation.
Correct.
So while it's going back for further investigation, then we can send the policy, and that's how we begin to the discussion with the stalking policy, and then in turn preventing deaths that are unnecessary.
Right. That's what we want to do.
From my understanding, I think what the motion we had made and voted on is directly what she had said. So now.
Do you have to take we don't have to take a vote on that, I don't think.
No.
Okay.
No, we've already voted on it and approved it.
Right, but there's no modification, is what I'm saying. Okay.
Move we adjourn.
Do I get a second?
I second.
All in favor, say aye.
Aye.
Anybody opposed? This meeting is over.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.